So let me get this straight. You want me to pay you £50,000 for the copyright infringement, legal costs, and a further £100,000 in general damages? Is that what you're telling me? Well, that's a fair offer. That's a very fair offer. Your client is wrong. He's lying. His whole story is made up. We have witnesses. We have evidence. My client is innocent. We will win in court. Your client is a liar. I know he is. He told me so. We can settle this right now. How much do you want? Give me a figure. What do you want? Let's settle this once and for all. Well, we've already agreed £150,000. We've gone through all the calculations. Your client is bankrupt. He's worthless. He's got nothing. So forget about the money. All I want is an apology. Well, you know what? I think I'm going to court. Hello. Welcome back to another episode of Legal Drama. Just kidding. This is not an episode of Legal Drama, but if it was, what would it be called? Season 1, Episode 3, ADR, Alternative Dispute Resolution. Well, when two or more parties have a dispute and they want to resolve it outside of court, they can use a number of different methods of alternative dispute resolution. So what is a DR? A DR stands for Alternative Dispute Resolution, and it is just that. It's an umbrella term that covers any dispute resolution methods that are available outside of court. Well, how does a DR differ from litigation? Well, litigation is the process of resolving a dispute through the court system. However, as we saw in the previous example, the court process is long, it's complex, and it's expensive. Most people would seek to resolve their disputes without going to court. What are the main types of a DR? There are 4 main types of a DR: negotiation, mediation, conciliation, and arbitration. So let's look at these in turn. First of all, we have negotiation. Negotiation is the oldest and simplest form of a DR. It involves the parties attempting to resolve the dispute between them directly. It's basically like a face-to-face meeting or maybe a phone call trying to sort things out between yourselves. There are no third parties involved in negotiation. So what are the advantages of negotiation? First of all, it's quick. Secondly, it's cheap. Thirdly, it's flexible. Fourthly, it's confidential. And fifthly, it's consensual. However, there are some disadvantages. One disadvantage is that it requires the parties to trust each other. And if there's a power imbalance between the parties, then this could cause difficulties. Another disadvantage is that there is no third party to assist the parties in their discussions. And finally, there is no record of the discussion or the final agreement. If an agreement is reached, it's not binding on the parties. It's not legally binding. Secondly, we have mediation. Mediation is also a popular form of a DR. It involves a third party, the mediator, assisting the parties to reach a settlement. The mediator is neutral. He doesn't take sides. He's not there to decide the case. He's not a judge. He's just there to assist the parties in reaching a settlement. The mediator might ask questions and suggest ways forward. But ultimately, it's up to the parties to reach an agreement. So what are the advantages of mediation? First of all, it's quick. Secondly, it's cheap. Thirdly, it's flexible. Fourthly, it's confidential. Fifthly, it's consensual. And finally, it can be tailored to the needs of the parties. There are some disadvantages. One disadvantage is that it requires the parties to trust each other. And if there's a power imbalance between the parties, then this could cause difficulties. Another disadvantage is that there is no obligation on the parties to reach an agreement, and finally, there is no record of the discussions that took place during the mediation. However, there are strict rules of confidentiality around mediation. So anything said during mediation cannot be referred to in court proceedings. Next, we have conciliation. Conciliation is similar to mediation except that the conciliator may suggest ways forward and may suggest solutions to the dispute. Conciliation can take place before or after court proceedings have started. Early conciliation takes place before proceedings have started, and conciliation can also take place whilst proceedings are ongoing. For example, in England and Wales, The online court system will not allow a claim to be submitted to the court unless the parties have first tried conciliation. This is known as early conciliation. If the parties are unable to settle their dispute through early conciliation, then the claim goes to the court and is issued online. Once a claim has been issued to the court may encourage the parties to participate in conciliation. This is known as court-assisted conciliation. So what are the advantages of conciliation? First of all, it's quick. Secondly, it's cheap. Thirdly, it's flexible. Fourthly, it's confidential. Fifthly, it's consensual. And finally, it can be tailored to the needs of the parties. There are some disadvantages. One disadvantage is that it requires the parties to trust each other. And if there's a power imbalance between the parties, then this could cause difficulties. Another disadvantage is that there is no obligation on the parties to reach an agreement, and finally, there is no record of the discussions that took place during the conciliation. However, there are strict rules of confidentiality around conciliation. So anything said during conciliation cannot be referred to in court proceedings. Finally, we have arbitration. Arbitration is a more formal type of a DR. In arbitration, the parties agree to submit their dispute to a third party, the arbitrator, who will make a decision which is binding on the parties. This is quite similar to court proceedings, although the rules are less strict in arbitration. So what are the advantages of arbitration? First of all, it's quicker than court proceedings. Secondly, it's cheaper than court proceedings. Thirdly, the parties have more control over the process. Fourthly, the decision maker is usually an expert in the field. And fifthly, the decision is binding on the parties. There are some disadvantages, however. One disadvantage is that the decision is binding on the parties and it's difficult to appeal. Another disadvantage is that it can be expensive if the dispute is complex. And finally, it's not suitable for all types of disputes. So when is a DR suitable? Well, a DR is suitable in most cases where there is a dispute between two or more parties. However, it's not suitable in every case. For example, a DR is not suitable where there is a serious power imbalance between the parties, where one party is particularly vulnerable, or where there is a crime which has been committed and it is in the public interest for that to be prosecuted. So let me give you an example of when a DR might be used. So Tom and Joe are business partners. They run a company together. Unfortunately, they fall out and they can't agree on how to move the business forward. They decide to go their separate ways and they need to agree on how to split the assets of the business. Now, this is a perfect example of when a DR might be used. Both Tom and Joe want to reach a settlement. They want to agree how to share the assets of the company. They want to do this quickly and they want to keep it confidential. A DR would be perfect in this situation. They could agree to use mediation or arbitration to resolve their dispute. So let me give you another example of when a DR might be used. Sam is a tenant and she falls into rent arrears. Her landlord wants to evict her for non-payment of rent. This is another example of where a DR might be used. The landlord and the tenant want to resolve the well. Hello there and welcome back to the channel. I'm your host. This is a new episode. Today's topic is Alternative Dispute Resolution, which is a core module in the legal skills course offered by a provider of legal education. So if you're interested in studying law, make sure to visit their website. Today we'll be exploring the ADR procedure, including various methods such as negotiation, mediation, conciliation, and arbitration, along with the circumstances in which each of these might be used. Before delving into a DR, let's first define and differentiate between two key concepts: dispute resolution and conflict resolution. While the terms are sometimes used interchangeably, they have distinct meanings. Dispute resolution refers to the process of settling disagreements between parties, often with the help of a neutral third party. Conversely, conflict resolution focuses on addressing the underlying causes of a deeper-rooted disagreement, aiming to achieve a lasting solution. Let's illustrate this with an example. Imagine two neighbors disputing over a property boundary. In this scenario, The dispute centers around a specific and clearly defined issue. Through negotiation or mediation, they reach an agreement on the boundary, resolving the dispute. Now consider another situation where two coworkers have conflicting personalities, leading to tension and communication breakdowns. Here, the conflict extends beyond a singular issue and delves into the personal dynamics between the coworkers. Resolving this conflict requires addressing the root causes of the tension, fostering better communication, and potentially improving their interpersonal skills. In this case, conflict resolution aims to create a sustainable and harmonious working relationship rather than merely settling a specific point of contention. Now that we've established the difference between the two, let's explore how to resolve a dispute. When a dispute arises between two or more parties, several options are available for resolution. One approach is to seek a legal solution. For instance, parties can opt to take their case to a tribunal such as a small claims court for a binding decision. They can pursue civil litigation procedures. Additionally, parties can explore funding options to support their legal actions, such as through legal aid or crowdfunding platforms. However, these legal routes can be lengthy and costly. Hence, many individuals and businesses opt for alternative dispute resolution procedures. So what exactly is alternative dispute resolution, or ADR? ADR encompasses several methods including negotiation, mediation, conciliation, and arbitration. Unlike traditional litigation, ADR procedures are typically private, flexible, and less adversarial. Let's now delve into each ADR method. First, negotiation. At its core, negotiation involves direct communication between the parties to a dispute to reach a mutually acceptable solution. It is often the first step taken to resolve conflicts and can be done directly by the parties or through their representatives. Negotiation relies on compromise, clear communication, and a willingness to find common ground. Next, mediation. Mediation involves a neutral third party known as the mediator who facilitates discussions between disputing parties to help them reach a settlement. The mediator does not impose a decision, but guides the parties toward a mutually agreeable solution. This method is commonly used in family law, commercial disputes, and labor relations. Third, conciliation. Conciliation is similar to mediation, but typically involves a conciliator who has more authority to suggest solutions and may even draft a binding agreement. It is often used in employment disputes and international commercial arbitration. Lastly, arbitration. Arbitration involves submitting a dispute to a neutral third party known as the arbitrator who renders a binding decision. This process is more formal than mediation or conciliation, but less so than litigation. Arbitration is often used in complex commercial disputes, intellectual property cases, and international trade agreements. These four methods offer diverse approaches to dispute resolution. While negotiation and conciliation are more collaborative, focusing on reaching an agreement, arbitration is more adversarial, resulting in a binding decision. Now let's look at when to use each method. The choice of ADR method depends on the nature of the dispute, the parties involved, and their desired outcomes. Negotiation is suitable for most types of disputes, as it is the simplest and least costly method. Mediation is effective for complex disputes where collaboration is desired, such as in family law matters or environmental issues. Conciliation is often used in employment disputes or situations where a structured approach to reaching an agreement is necessary. Arbitration is best suited for commercial disputes or when a legally binding decision is required. Here's a simple table summarizing the usage of each method. Nature of dispute. Most types of disputes. Complex disputes requiring collaboration. Specific areas like family law or environment. Employment disputes or situations needing a structured approach. Commercial disputes or where a legally binding decision is required. Process description. Direct communication between parties, guided by a neutral third party. The mediator, more formal than mediation, but less than litigation. Neutral third party, the conciliator, who suggests solutions and may draft an agreement. relies on a neutral third party, the arbitrator, who imposes a binding decision. If an ADR agreement exists, then you cannot go to court, and this can be seen in case law with Mitsubishi Motors Corporation v. Solar Chrysler Plymouth, Inc. Likewise, legislation supports this with the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, New York, the 10th of June 1958. The key strengths of ADR. Firstly, ADR is often quicker than litigation as it avoids the need for court hearings and lengthy procedures. Secondly, ADR is more cost-effective as it typically involves lower fees compared to legal representation and court expenses. Thirdly, ADR is more flexible than litigation, allowing parties to tailor solutions to their specific needs and maintain control over the process. Fourthly, ADR promotes collaboration and communication, fostering better relationships between parties. Lastly, ADR is confidential, protecting sensitive information from public disclosure during the dispute resolution process. Now let's move on to the strengths of ADR. Firstly, ADR is often quicker than litigation as it avoids the need for court hearings and lengthy procedures. Secondly, ADR is more cost-effective as it typically involves lower fees compared to legal representation and court expenses. Thirdly, ADR is more flexible than litigation, allowing parties to tailor solutions to their specific needs and maintain control over the process. Fourthly, ADR promotes collaboration and communication, fostering better relationships between parties. Lastly, ADR is confidential, protecting sensitive information from public disclosure during the dispute resolution process. To illustrate the strengths of ADR, consider a business partnership facing a contractual dispute. Instead of pursuing costly and time-consuming litigation, the partners can opt for negotiation or mediation to reach a mutually acceptable solution, preserving their business relationship. By utilizing ADR, the partners save on legal expenses, avoid public scrutiny, and reach a resolution tailored to their specific needs, allowing them to move forward with their business. Now let's look at the weaknesses of ADR. Firstly, ADR may not be suitable for all types of disputes, particularly those involving criminal matters or violations of public policy. Secondly, ADR can be challenging when dealing with parties who are unwilling to compromise or communicate effectively. Thirdly, ADR outcomes may lack the enforceability of court orders, potentially leading to non-compliance by parties. Fourthly, ADR can be biased towards parties with greater power or resources, potentially resulting in unfair agreements. Lastly, the confidentiality of ADR proceedings may hinder public accountability and transparency. For instance, in a case of workplace discrimination, ADR may not be appropriate due to the violation of public policy or the need for public accountability. Additionally, if one party is unwilling to compromise or communicate effectively, ADR may not yield a successful outcome. And finally, let's discuss the main reasons parties opt for ADR instead of litigation. Firstly, ADR is generally less costly than litigation, making it more accessible and appealing to parties with limited resources. Secondly, ADR is more efficient and faster than litigation, providing a quicker resolution to disputes. Thirdly, ADR offers greater flexibility, allowing parties to tailor solutions to their specific needs and maintain control over the process. Fourthly, ADR encourages collaboration and communication, fostering better relationships between parties. Lastly, ADR is confidential, protecting sensitive information from public disclosure. For example, two neighbors disputing over a property boundary may choose ADR to resolve their conflict quickly and amicably, avoiding the expense and stress of litigation. Now let's look at some examples of ADR. In the realm of employment, ADR is widely used to resolve issues such as health and safety concerns, equal pay claims, compromise and severance agreements, and wrongful or unfair dismissal claims.